I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we focus on individual rights under U.S. state laws. There are so many buzzwords in this space, so if we start talking about things in abbreviated ways, I'll need your patience, but they come in a variety of different forms, and they're referred to in many different ways. Things like the right to know, access, delete, correction, sales opt-outs. There are so many rights that we are seeing emerge, and they seem to be growing in number and evolving in substance with the passage of each new state law. At bottom, these rights serve an important privacy interest for consumers in the United States. They give people the ability to exercise some control over their data, some knowledge about how their data is being used and who has that data. But these interests really only can be served if legislatures who are creating these frameworks find workable and practicable standards that allows organizations to effectively comply in today's complicated digital ecosystem. To make things even more difficult than that, rights are differing state by state. And so while there is some conformity and a baseline set of rules under the GDPR in the EU, there is no one set of rules in the US. And the rules will depend on a number of factors like residency of the individual, the types of data involved, the context in which the data is collected, and whether data is collected by specific types of regulated entities like healthcare organizations and financial institutions. And even where the rights appear similar across state laws, the text still differs, and which creates really intended or maybe unintended nuances that need to be appreciated as organizations seek to implement these standards. These differences create challenges for organizations to deploy a common set of standards across their US and global operations, and we're often asked by clients to make sense of it. So that's today's episode. And to discuss, I've invited two of our privacy and cybersecurity attorneys on the Hogan team, Aaron Lariviere and Rachel Parrish, to the podcast. Both Aaron and Rachel have spent a lot of time in the weeds examining the differences between the various standards so our clients don't have to. Aaron, Rachel, welcome to the podcast.
Thanks, Scott. Glad to be here.
Happy to be here, Scott.
Well, Aaron, maybe I can start with you. Can you maybe provide the audience a snapshot of where we find ourselves? This is being recorded on the last couple of days in July in 2024. Where do we see ourselves with the emerging state laws? And in particular, what types of individual right obligations are we seeing under those laws?
Absolutely. So we currently have 19 state comprehensive privacy laws. Well, depending how you count. If you count Florida, which applies more narrowly, we have 20 state laws. And these have been passed with increasing frequency over the past couple of years. Quite a few of these have just come in over the last several months. Each of these are different in some ways with some key distinctions, as you mentioned, with respect to these rights. I won't run through every state that has a law because there are so many, but we started with California. The most recent one passed was in Rhode Island. We've seen quite a few, and they come in a wide range of forms at this point. Just to give a little bit of context about the different laws, California kind of set the baseline for U.S. comprehensive privacy laws, with the CCPA, which has since been amended and expanded both with the passage of the California Privacy Rights Act and also the enaction of some pretty detailed regulations issued by California regulators, which have really expanded on the details around data subject rights in particular. So there's a lot of law in this space. And that's just California. Since California was passed, we had laws pop up in Virginia and Colorado. And then the model of those statutes was kind of adopted more widely across a number of other states. Now, as I mentioned, we're up to 19 in that broad mold. The more laws that pass, the more divergent they become. In some of the more recent laws we've seen, such as laws in Oregon and Maryland, we've seen some more specific differences emerge. Oregon has really gone further with respect to the disclosures you might be required to provide upon request about the various third parties. I'm getting ahead of myself, but just wanted to flag that, as these continue to come in, legislatures keep finding ways to tinker with the text to expand on the rights or in some ways narrow them. And it just makes it tricky to navigate when you're trying to advise clients for compliance across the US, right? You have to think about it. How do the laws differ? What is specifically required in each context? Because you might get a request from somebody in one state versus another. In the required approach might be slightly different. Just to give an overview of the rights that we are thinking about here, I think a lot of this will be familiar to folks who have been thinking about the rights that arise under the GDPR. A lot of these overlap, but there are some new rights and some distinctions here. So the rights we're specifically thinking of are the right to know, the right to access, portability, deletion, correction, various opt-out rights around things like sales, sharing, targeted advertising, profiling, and automated decision-making, a right to request appeal of a decision related to your rights, a right to anti-discrimination. And we could describe rights all day. There are even some more about relating to financial incentives and sensitive information.
So, Aaron, that was a really helpful overview. And maybe, Rachel, I'm interested in your perspective on a couple of things that Aaron mentioned, because these laws that are coming up, the 19 or so that we have right now, they don't apply equally to every organization across the country. In fact, some consumers and organizations seeking to comply may be surprised that individuals in California may have some rights that folks in Virginia don't have, and vice versa. Interested in your perspective on those threshold questions about where these laws would apply and, importantly, where they may differ in their application.
Yeah, that's absolutely right, Scott. The scope of the laws is completely different. There's certain types of businesses that certain of them scope in and scope out. A good example is how the different state comprehensive laws handle nonprofits. So Colorado explicitly scopes in pretty much all types of nonprofits. Virginia scopes in some but not others. And a lot of the other statutes have different types of approaches there. So it's definitely important to kind of get into the weeds and look at those scoping questions. Other things that may fall in California, employment data falls in, where that is scoped out of much of the other statutes, B2B data, HIPAA, the GLBA, all these different kinds of things definitely affect what's scoped in and scoped out. So it's important to, get into the weeds and make sure that the correct rights are being provided to individuals that have them.
Yeah, really important points, Rachel. Aaron, maybe before we dive into what these rights look like, I think it's probably fair to point out that, these rights were not first created under these new laws, right? In other words, there have been very specific rights in some contexts in the United States. There are broad rights elsewhere in the world, including under the GDPR, but I'm thinking of rights that exist under California's Shine the Light laws, or the rights that are under HIPAA with respect to access or correction, rights that FCRA created. I'm just kind of interested in perspective about how you see all of these things interacting, and then maybe we can start talking a little bit about what they mean.
Yeah, it's a really good point. So as you mentioned, before we had comprehensive state privacy laws, we had a lot of sectoral laws that provided what I would generally say are narrower rights or less expansive rights in many ways. What we have here was the CCPA drafters really looked to the GDPR in a lot of ways, and they really expanded on the types of rights to apply them more broadly, to almost model them on the types of rights we were seeing in coming into effect in the EU in particular. So these go beyond a lot of what we'd seen under the other laws. Now, I will say it's important to remember, as Rachel just mentioned, there's sometimes complex interplay between the existing federal laws and sometimes state laws that provide these rights and these new state laws. Sometimes, for example, HIPAA or GLBA, those rights might still apply under those laws because a lot of that data is going to be carved out of these state laws. So when you get a request, you may have to evaluate, which framework are we operating under? What are we subject to? Whether we fall into one of these state law frameworks or whether we're still in the existing, the old world frameworks that we've been living with for a long time. So yeah, it really does make this Tricky space to navigate.
All right. Well, fortunately, I have the two of you on the podcast, so we can start bringing some order to this. Let's just talk about what these rights look like, because there's so many kind of abbreviations from DSARs that sometimes people can get confused. There's a reference to the right to know and the right to access and the right to delete. Aaron, maybe I can ask you first to start walking through some of them. And then Rachel, I'm interested in your perspective on some of the others.
Sure. Yeah. Just to start with, I think the right to know is an interesting one to explain. It's not a term we'd heard under the GDPR or previous privacy laws. What the right to know really means is it gives the consumer the ability to request a disclosure, confirming whether a controller is processing personal data about that consumer. Now, this varies a bit depending on the specific law, but that's the basic requirement. So it's really just to know whether or not the controller is processing your information.
Rachel, I'm thinking about access. What does an access right look like here?
Yeah, Scott. So this idea of access, it kind of piggybacks on the idea of the right to know, but takes it one step further. So it's not just that a consumer has the right to know that their data is being processed. It's the idea that a consumer has the right to access those specific pieces and categories of information that a controller is processing. And that kind of goes hand in hand with this other sort of sub-right called the right to portability. And that's sort of a technical fancy term, just comes from the word portable, right? You need to be able to sort of move this data around in a meaningful way, in a way that it can be disclosed to the consumer in a readily usable format that can be transferred to another controller that sort of offers a similar service. So something I use to kind of, wrap my mind around this right when I'm explaining it to folks is I'm a big reader. And so if I was creating sort of a virtual category of books that I read on any given website, so if I was requesting access and portability as a consumer under one of these laws, I would do that request, and then the data would be transferred to another sort of virtual library service to kind of auto-populate the same exact shelf with all my classic favorites and all the new fiction that I'm trying and all those kinds of things. So that's sort of how those two rights would work.
So, Rachel, does it also extend then further? So taking your virtual library example, let's say I didn't want to have the world know that I read, this spy novel. I wanted to now have that be removed from the universe. Is there a right to delete as well?
You better believe there's a right to delete, Scott. It's one of my personal favorite rights. So it's the idea that a consumer has the ability to request the deletion of their information. And there's a key distinction here that we'll talk about a little bit later. The type of information that is allowed to be deleted sort of varies based on the state. That's one of the key differences that Aaron and I have been advising a lot on. So it's extremely important, Scott. Nobody's going to know about that spy novel if you don't want them to.
All right. So as I understand it, we have the right to know, which allows individuals to know who is processing their data. I have the ability of potentially accessing the data they have about me, maybe moving it to another platform through a portability request, and have the ability of deleting it. Aaron, interested in some of those other big categories, perhaps correction.
Sure. Yeah, there's a right to correction. So if a consumer can submit a request to correct incorrect or outdated personal information. There's a wide range of opt-out rights under the various state laws. Those include, opt-outs to sales of information, sales in quotes. There are also opt-outs for the sharing of information for the purposes of cross-context behavioral advertising or opt-outs to targeted advertising generally. There's a profiling opt-out right under many of these state laws. There's also a right to submit requests to appeal a decision about a consumer's request to exercise any of these rights. That arises under several state laws. There's an anti-discrimination right, meaning consumers have the right not to be discriminated against because they submitted a request relating to their data subject rights. And then there are some other rights related to financial incentives, to opt out of a financial incentive that you've agreed to, or with respect to sensitive data. And the differences between state laws on those fronts get quite distinct as you run them down.
And we can't have gone this far into the podcast describing all of the various individual rights and not mention the big one, the ability of opting out of sales. That's probably, 3 or 4 hours of podcast material just on that subject, but want to make sure, Aaron, that you kind of flag that one amongst the list given its importance.
Yeah, no, that is a key right. And so the way to think about the sale opt-out right, this was a new right that was introduced under the CCPA and then kind of adopted more broadly under the other state laws in some form or another. And I'll just say, California defines what counts as a sale to mean a disclosure of personal information to a third party for monetary or other valuable consideration. And what that means is that's disclosing or making available personal data to a third party, perhaps in exchange for money or perhaps in exchange for just any benefit. So we really interpret that pretty broadly to mean basically making available information to another controller unless certain statutory exceptions apply. Now, other states in many cases adopted the same very similar version of that right and used the same definition of sale, but some states reined it in a little bit. So for example, Virginia and a few of the other states have a narrower definition of sale where it only means a transfer for monetary consideration, how we would normally interpret the word sale to mean. California and some of the states expand that to account for transfers even where there's no money exchanged.
And then we have rights with respect to shares, which means something slightly different than
Yeah,
sales.
exactly. Yeah, California, when they passed the California Privacy Rights Act in 2020, they basically expanded on the sale right. And so they introduced this concept of sharing, which has a strangely narrow definition. It doesn't mean sharing with anybody. It just means sharing for the purpose of cross-context behavioral advertising. So really the way we think about that is when there's a disclosure of information for advertising purposes, across websites or across, services, whether it's to a service provider or not, it doesn't matter. That's going to be considered a share that requires an opt-out. Other states have a similar concept, although they call it something different. They call it the right to opt out of targeted advertising. They do apply quite similarly, although those states don't actually require a disclosure to that third party. You just have to provide an opt out to the targeted advertising generally. So there's a little bit of difference in scope there. And I think that's kind of consistent with the way a lot of these laws are drafted, with just slight tweaks to either the framing of the right itself or the scope of which it applies.
So super important. And as I said, like shares and sales and the ability of opting out of sensitive information, all of those end up kind of being very nuanced types of analyses. And perhaps, Aaron and Rachel, I'll have you back to kind of examine those issues. But let's maybe move the conversation to some of those other categories and start to spend time seeing, all right, we know what a no right is, the ability of understanding who is processing or what organization is processing a consumer's data. And as I previewed in the introduction, the no right is also subject to differences in individual states. Where are you seeing some of those key distinctions for maybe starting with the right to know, and then we can move on to some of the other rights?
Yeah, it's a great example of a right where there's just significant differences across the states. So California introduced this right, and in the regulations, they really expanded on it. They actually require that you provide an individualized response. In most cases, you usually can't just link out to your privacy notice to describe the categories of information, unless that privacy notice would be describing the same types of information that are applicable to every category of data subject. So there's some nuance there. You, in many cases, may have to develop template responses to comply with this California right. Most other states, I'll say, are a little bit more agnostic about how you do this. They don't give quite the granular requirements that the California regulations do. But something we've seen in some of the more recent statutes is a significant expansion of this right that goes way beyond what California requires. Oregon was the first state to introduce this, and essentially they require, under Oregon law, that a consumer can request disclosure of a list of all the third parties to whom you disclose information. And there are some carve-outs to that. It's not going to require you to disclose every service provider, but essentially to any third party who you make this information available to, you're going to have to list them by name. We've never seen that under any of the state laws. As far as I'm aware, I don't think we've seen that under any of the global laws, or at least not under GDPR. So this is a new and quite onerous requirement that a lot of our clients are starting to think through. We've also seen some of the other state laws provide different versions of that since then. So Maryland provides the ability to obtain a list of third parties. They draw a few distinctions between the Oregon approach. You are also available to provide a list of third parties to whom the controller discloses any information. So it doesn't have to be specific to that single consumer. They give a little bit more flexibility there, but it's a similar concept. And then we've seen similar rights arise under Delaware and Minnesota, although there are some nuance. I think Delaware is a little bit narrower. Minnesota is even a little bit broader. We're just seeing states kind of innovate in the ways they provide these rights. And in some cases, they can be quite impactful.
Yeah, and innovation here, well, typically like, oh, well, it's great to innovate. In this case, when the states innovate, it just makes it more and more complicated for organizations to find a path forward for compliance. And, as I look at these, another area where the different states have different standards is with respect to deletion, because deletion tends not to be an absolute right. Where the states provide a right to deletion, it's subject to a number of exceptions, but those exceptions may also differ amongst the states.
It's a really good point. And I think this is very acute in the context of the deletion right. So just in general, there's a scoping difference for a lot of these laws. California and some of the others have a narrower scope where they only provide a deletion right for information collected from the consumer, which we interpret to mean it's not necessarily going to apply in every instance where the information was collected from a third party rather than directly from the consumer. There's some nuance there that's worth running down depending on the state. But a lot of other states have a broader right, and it does cover information collected directly from the consumer or, more generally about the consumer. So which would apply more just to the information you hold. In addition, as you mentioned, there are an enormous amount of exceptions that apply in different ways. Now, that means there are statutory exceptions that are going to apply differently. As we mentioned before, some types of data are just carved out of these statutes. So for example, we're going to be thinking about employee and B2B data in the California context, but generally not under the other state laws. And then there are these, entity level exceptions under certain statutes. And then there are specific rights-specific exceptions. One of the ones that comes up often and in different ways across the states are exceptions for things like trade secrets. This is also going to apply in the context of access rights in particular, but the way trade secrets are handled are quite different under some of these laws. Some states provide a clear exception for honoring a rights request that would require, disclosing a trade secret. Some do not. Virginia doesn't even talk about trade secrets at all. So these are things that cause a lot of heartburn for our clients as they're trying to iron out what they do and don't have to disclose or do and don't have to delete. And oftentimes requires, a pretty close look at each of the statutes.
Yeah, I mean, that close look of the statutes is a key point, because maybe Rachel, interested in some of the examples that you've seen. So for example, I know as you were discussing, portability itself is subject to a number of distinctions around the file formats and how the states set out what needs to be portable / in what form it needs to be provided in order for it to be portable. And I know there's some distinctions around trying to even scope what's personal data and what's not personal data, around kind of what's publicly available and what's not. Interested in some of those key threshold definitional differences that we see amongst these states.
Yeah, Scott, the states definitely got creative with this idea of portability. It seems almost as if as many laws as there are, there's a different approach to defining these different file formats and the scope of applicability that differs. I think a key distinction I would flag is that, California provides the broader right to anything, data that needs to be portable is anything that was obtained from the consumer. Other states provide copies of consumers' personal data held by the controller, which is obviously a little bit different than obtained from the consumer. There's all kinds of nuances and distinctions here. And then file formatting distinctions as well. There's different states approach it different ways about essentially how practicable it has to be. So some use the term to the extent technically feasible, some use to the extent technically practicable. So there's different statutory language here that definitely plays out in different ways across the states.
Right. And presumably these rights have deadlines associated with them. So in other words, when an organization receives a request from Aaron for access to the data, they can't just sit on that request indefinitely. Otherwise, it wouldn't be an effective right. Presumably, the states are also setting different deadlines for responses and perhaps extensions with respect to these requests.
Yeah, that's absolutely right, Scott. So for timing, it's also another big area of nuance. California creates this responsibility for controllers to respond to the request within 10 days to kind of acknowledge receipt, be like, we've got the request, we're working on it. And no other states provide that, which is an interesting requirement that businesses need to be aware of. And then pretty much the baseline rule is that a business will have 45 days to respond meaningfully to a consumer request, but there's our nice little carve out of Iowa who provides a 90-day timeline. So the extensions, you're absolutely right there as well. So typically it's based on the period. So for our 45-day states, they get a 45-day extension, but Iowa's got that little quirk with the 90-day extension, not a 90-day response, not a 90-day extension, a 45-day extension. It's an important distinction there.
I mean, these distinctions and these differences and the subtlety around them and the timelines associated with them, are all just kind of, I think, make many people's head hurt. Right? I mean, if you think of why is it that the need for federal legislation, is evident, and you probably look to these rights and say, like, why is it that there is one standard in California and another standard in Virginia and another standard in Maryland? Like, why are we not giving all U.S. citizens the same rights? So maybe that will be, in the future. But at the moment, we are left with this position where we are probably forced to have this headache and forced to feel like we are just swimming in all of these details as we take this very complicated puzzle and start to try to make any sense of it. And maybe I'm interested, Aaron, in your perspective, especially as you're advising, companies operating across U.S. states and companies that are operating globally. How are you approaching this? How are you trying to bring order to what appears to be a very chaotic landscape?
It's a great question. First and foremost, we're talking to our clients to really understand their needs. This is something that actually just differs so significantly depending on your sector, depending on your business, depending on the type of data you hold and where you operate, right? You may be a business that's been processing data subject rights for years under the GDPR and other laws, and you might already have processes built up around this. Or you might be new to this world. Perhaps you only operate in the US and you're only now becoming subject to some of these laws. Sorry to raise the red flag for everybody, but these requests are going to come in regardless of whether you've gotten them in the past or not. We're starting to see them more and more across all sectors. So it's only a matter of time. This is going to be relevant to everybody. But what we're really doing is we're talking to our clients, helping them kind of look at the broader picture and focusing on some key decision points. First of all, how does the company generally want to approach their rights response process? Do you want to offer rights universally? Do you want to offer them to all consumers? Like if you're a B2C company, you might have a reason for offering rights that perhaps you aren't even required to offer. Not saying you should or you have to, but some businesses choose to do that just for simplicity's sake, but also, for messaging perhaps. Others take a totally different approach and they might only want to offer the rights where strictly required, right? And you can do that too. It just requires having a pretty nuanced process and being willing to kind of assess whether or not each request that comes in from somebody who lives in a state that provides that right. So those are the types of questions we look at. How do you want to offer them? What is your baseline approach going to be? Do you want to reach kind of a lowest common denominator approach where you can offer the same type of rights response to consumers regardless of jurisdiction? Or do you want to tailor your response by jurisdiction? Something I think we see quite often is we'll see perhaps one approach in the EU generally, one approach across the US, more broadly, and then perhaps with some distinctions, where there are some really specific differences under the state laws, typically around like opt-out rights, those types of things. But it really can vary, and we've seen a lot of approaches here.
And presumably, Aaron, as you're thinking about that, about those choices, some of those are going to come down to, okay, what's pragmatic? How is it that I can be able to manage these differing obligations? Some of them can be value based. Some organizations say, hey, this is part of what we want to do from a cultural perspective and from a customer engagement perspective. There is obviously legal risks going each way, not necessarily all that clear about which one is better than the other, but there are options, but those options need to be dictated by strategy as opposed to saying, hey, here is what the law requires, because in this case, the law requires many different things and it's not consistent in the direction it's traveling.
That's exactly right. And if in a perfect world, I think it'd be great for businesses to put in place a data subject rights response policy, build out appropriate processes where they make those decisions, where they've really, thought these things through. They've decided how they want to intake requests, how they want to respond to requests, how broadly they want to offer them, who's responsible for fielding requests as they come in, when to escalate. These are a lot of the types of things we'd be thinking about when we're working with clients to basically be strategic about these questions.
Yeah, I think that's exactly right. I imagine it's also going to really emphasize the need for technology solutions to help automate some of this, because you can imagine if you are experiencing a lot of these types of requests, given the nuances, you can spend a lot of time and energy and resources trying to respond to each one. And so the need for tooling that will help, bring some consistency will be really needed for this to operate at scale.
For sure. And, the approach depends on the business, of course. Many will automate things like opt-outs for sure. Also, sometimes access requests can be automated in certain ways, or deletion requests, depending on the nature of the service and the data you hold. Other businesses perhaps aren't receiving quite so many requests. Perhaps if you're a B2B organization, you may not be getting these as often in the US. So you might have a more manual process. You might just build it out with your internal team. But we see a range of approaches. Some teams choose to build their own internal processes. Sometimes you pull in a third party service provider who has rights request, compliance solutions. We're seeing a range of approaches, and you typically tailor it based on your needs, based on the types of data you hold, based on, the types of requests you've seen and what you're anticipating in the future.
So maybe my final question is, I think you both made the point that this is where we are at the end of July in 2024. My guess is that if we're having this conversation again in July of 2025, if you guys agree to come back on the podcast, what are we talking about then? I have my own guesses, interested in each of your perspectives about where you see the next shoe to drop.
Well, I'd love to have federal privacy legislation by then, but I don't know if it's going to happen. What I expect we're going to have some more states probably passing some more laws at some point in there. A lot of these states' laws will have taken effect by then. So I'm expecting we'll start to see a lot more requests to come in. Perhaps we'll start to see some enforcement around these. I know when the CCPA was new, we were seeing enforcement requests come in related to rights requests. Oftentimes a consumer would submit a request and perhaps get denied. They just subsequently file a complaint, and we'd see those complaints getting forwarded back by the regulator directly to our clients, and we'd be helping them with a response, right? So I don't know exactly what enforcement is going to look like across the various states. It might differ quite a bit, but we might see some more of that as more of these laws come into effect and as more people become aware of these rights. But I think the general trend is these rights are not going anywhere. I expect consumer awareness around them to increase, and I expect legislatures to continue to innovate, as we said earlier, on new ways to require our clients to take action with respect to data subject rights.
Yeah, just absolutely piggybacking off everything Aaron said. I think tying back to something he said at the very beginning of how the laws are becoming more and more divergent as more laws drop. So I would just expect to see a continually shifting landscape with more laws being passed, more obviously laws being implemented and becoming effective, and just more and more nuance, Scott. That's what I would predict.
And if I can add one to your list, I agree with everything that each of you have added. I would maybe keep an eye out for what cookie banners are going to look like in the US over the course of the next year. Because while we don't have a law in the same way that the EU does around the uses of getting opt-in consents for the uses of cookies, it seems as though that the direction of travel with respect to the FTC's enforcement priorities, where it is that how is that they are closely examining trackers, and then importantly, my guess is that some of the state legislatures will say, "Hey, why are we not giving those same types of rights to individuals in the way that folks in the EU have, or the way that the FTC expects?" My guess is that's also the future. And that if you ever been to Europe recently, you'll probably have been spammed with all of these cookie consent banners. Sadly, that may also be the state of play in the US come July 2025.
We shall see.
Well, with that, Rachel, Aaron, I really appreciate your joining the podcast and sharing your insights and really helping bring sense to an otherwise area where it's very difficult to sort through things. So thank you so much for joining.
Thanks, Scott.
Thanks, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.